All right, some administrative things. I believe we're on court 8, 9. Sorry about that. Court 9 is the note I gave to our alternate excusing her. Y'all were copied by email. Get that, Madam Court Order. C9. C10 is the 2-page question. C11, well, I won't number that yet. Well, yeah, I will. C11 is the question number 2. Y'all have been provided a copy by my staff attorney. Hear from the state first and then the defense.
Judge, as to question number 1, I believe that the correct response to this would basically just be yes. Isn't it true we should consider Mr. Barron's likelihood of reasonable apprehension of fear of immediately receiving violent injury from the perspective of a reasonable person in the known context? It's a reasonable person standard, so I think the answer to that would just be yes. And as to the second question, I think the obvious answer is yes.
All right, so question 1, is there any additional information you can provide beyond what is already in the jury instructions related to aggravated assault, specifically regarding ... or committed an act that placed the person in reasonable apprehension, it says, or fear, apprehension or fear immediately receiving a violent injury, close quote, question mark. Page 2 of question 1, isn't it true we should consider James Barron's likelihood of reasonable apprehension, quote, of reasonable apprehension or fear of immediately receiving a violent injury, quote, from the perspective of a reasonable person in the known context? So that's Court 10, page 1 and page 2. We'll go to C11 in a moment. Defense.
Talk about C10.
I'm talking about C10, which on your copy, it says question 1, and then there's a smaller to the top right that says 1 circled, which it leads me to believe that is page 1, and then 2 circled, which leads me to believe that's page 2. And so then there's a question 2. So on page 1 and 2, which is question 1, what say the defense?
The answer to the first question is the state must prove beyond a reasonable doubt the defendant's act of, quote, firing a weapon through a door, which is the allegata in count 4, placed James David Barron in reasonable apprehension of immediately receiving a violent injury. That's the correct answer. The state must prove beyond a reasonable doubt the defendant's act of firing a weapon through a door placed James David Barron in reasonable apprehension of immediately receiving a violent injury. That's the answer to 1. The answer to 2 is, on page 2, is no. Their question, whether or not they should consider James Barron's likelihood of reasonable apprehension or fear of immediately receiving a violent injury from the perspective of a reasonable person in the known context, that answer is no. The question is, you should consider whether the state has proven beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed him in reasonable apprehension of immediately receiving a violent injury. That's the correct answer to 2. They're confused, Judge, respectfully, and I suspected that they would be. They're confused about whether or not they can just say, was he in reasonable apprehension, and not connect it to the charged allegata, which is by firing the weapon through the door. And so the response should be, state has to prove beyond reasonable doubt that the act of firing through a weapon through a door placed him in reasonable apprehension of immediately receiving a violent injury. That connects it up. And then the answer to 2 is no. It's not they don't just assume. They're asking, do we just assume whether a normal person would? That's not correct. The question is whether it's been proven to them beyond a reasonable doubt that he did. So the answer is no. They should consider whether it's been proven beyond a reasonable doubt that the act of firing a weapon through a door placed him in reasonable apprehension.
Response? State. You can come on.
Well, I was just trying to find couldn't figure out what page it was on, the charge on aggravated assault.
I believe it's page 11.
Oh, thank you, Judge.
It was 240-30.
So Mr. Willis's first statement as to the first page about the state has to prove, and then basically just implanting the language from the indictment in the statute is a correct statement of the law. I don't see any problem with doing that. I think the only thing that Mr. Willis and I differ on is the response to page 2, because I just think we differ on the answer to the page 2.
What's your proposal?
My proposal was to just answer yes. I don't think there's any problem with restating the statute, including the language from the indictment, because again, that's a correct statement of the law. But as far as, isn't it true, we should consider the likelihood of reasonable apprehension of fear of immediately receiving violent injury from the perspective of a reasonable person in the known context. I think that's where we differ. I'm reading the way that we charged them. I think I would prefer, if we're not going to respond yes or no, I think that I would prefer, as to page 2 of question 1, that we reply with, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving violent injury, and leave it at that. Because that's a correct statement of the law. The state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. That's directly from the charge of aggravated assault, the pattern. And so I think the state would just request that we put just that one sentence from the charge in the response. I think that directly answers their question. It's a correct statement of the law, and so that would be the state's request.
I think you should say no as a response to 2, and then I don't have an objection to reading that part.
All right, so let's, if you would, and I'm not saying I'm necessarily going to give these, your response to the second part, page 2, if you would type that up and send it to Mr. Preston, we'll print it out. Defense, your response on page 1, same, and then we'll compare notes, please. And then we'll focus on that before we move to question 2, please.
which is what I did.
Defense need a printed out copy, or you find on digital
Of the,
what the state just emailed?
I emailed it to you.
I have it.
Okay.
Are you okay with a digital copy?
with what they just sent?
Would you like a printed out copy?
No, sir.
Okay.
But we're not consenting to that. We want the word no in front of it. Okay.
I understand that. State, are you okay with the digital copy, or do you want to print?
I'm good. I'm good with that, Judge. I appreciate it. Thank you.
All right, focusing our attention on Mr. Willis's proposed answer. The state must prove beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension of immediately receiving a violent injury.
No, I have no objection with that, Judge.
That will be the answer to the first page, question 1. The defense is okay with this, but wants the qualifier of no in the beginning, if I understand. State's proposal, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury.
The reason we want the no, Judge, is because it's a specific question. Isn't it true? First question doesn't have that, just they want more information. So isn't it true? The answer is no.
State, I think the defense makes a fair point. I'll hear from you.
The reason why I'm hesitant to put no is because I'm doing some research on the validity of the no, and I think sticking with the pattern charge is a correct statement of the law, and
I'll give you a few moments to continue
Judge.
research. I'll hear from the state. The jury asks a specific question, and the answer is no. I'm inclined to put no period and then put in the response that the state proposes, essentially no period return, and then what you've provided by email.
I'm sorry, so putting no and then what I typed out, essentially?
Whoever did it, Ms. Ali's email.
Yeah, I'm using her computer, sorry.
Yeah, that's fine.
Okay.
That's not a final ruling, but that's where I'm going.
They're saying from any reasonable person's perspective.
And Judge, I'll just note, my counsel has reminded me, we had asked the court not to charge on
Yeah, they
both
are.
species of assault, and we're not waiving that previous objection to the charge. This is a previous objection we had, so we just want to note that we're not waiving that. We still don't think that we should have charged on both species of assault, the intent to injure and the reasonable apprehension. And after the court sends it back,
Noted.
yeah.
I think, so they're asking from his perspective. They're saying, so essentially, obviously, the right answer is, from his perspective, was he placed in reasonable apprehension of receiving immediate violent injury?
The person.
Correct, which would, in this case, would be Mr. Barron. So maybe just to make it, instead of putting a yes or no, instead of putting the person, we put in James Barron. So it reads, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed James Barron in reasonable apprehension of or fear of immediately receiving a violent injury. That way it's clear it's from his perspective. So it's beyond a reasonable doubt. So it's reading that committed an act that placed James Barron in reasonable apprehension or fear of immediately receiving a violent injury.
Which is what I proposed initially.
Well, if you proposed initially, then assume you're good with it now.
I'm good with it now. As long as I have a no at the beginning.
Well, that's what they don't want, so
What? I'm sorry.
he wants the no at the beginning.
Yeah, I would just rather not say yes or no and just restate the law, but including his name so that it's clear that it's not just any person, it's James Barron in reasonable apprehension or fear of receiving injury. Just because their question is kind of confusing, so answering with a yes or no is what concerns me, which is why I believe restating the law but including his name to make it clear that it's not just placing any person in reasonable apprehension, but it's that the act placed James Barron in reasonable apprehension or fear of immediately receiving a violent injury.
Defense can take a moment.
I'm sending the court my proposed response. It still has a no at the beginning.
Am I copied in it? Or
Yep,
can
you are.
Can you copy now?
I just sent it,
That's okay,
sorry.
I have my phone.
Let me forward it to her. Previously, they asked a specific question, and we gave them a yes or no, so I think we should tell them no. If it doesn't tell them no, then they think they're on the right track, and they're not, so.
I have no problem with what Mr. Willis has just sent. The state must prove beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension of immediately receiving. And reasonable apprehension, he did leave out the or fear. Reasonable apprehension or fear of immediately receiving a violent injury. I have no problem with that. Except for adding the or fear.
But it's not from the perspective of a reasonable person.
I know.
That's what
I'm saying-
hasn't been corrected, is what I'm saying. If we don't tell them no, then they can think, well, yeah, but did he do it? But now I'm just going to guess and see whether a reasonable person would. The answer is no, so we should tell them no respectfully.
Right. Include the facts.
What's the state's concern about telling them, no, it's not a reasonable person?
Because I find the question to be confusing based off of how they're viewing it. And I don't think that there's any error in simply restating the law to them, but including the facts of this case to make it clear. Like Mr. Willis's proposal of you should consider whether the state has proved beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension, and then adding or fear of immediately receiving a violent injury is an absolute correct statement of the law. It instead of just rereading the charge to them, it includes both the indictment language as well as the victim's name. And so I think that helps answer the question without potentially incorrectly answering what they might be trying to figure out, because I find their question to be confusing. And so I would prefer to just insert the facts of this case to the law and read that to them. It answers the question without a yes or no. It gives them the correct law without giving a yes or a no.
Last word, defense.
They've asked, isn't it true? The answer is no. We should tell them no and then tell them what the correct answer is.
Because, I mean, the reason why I think it's confusing, Judge, is because it's not like
Last word.
We'll go another round.
It's not like anybody could ask Mr. Barron, were you in fear? Because he's dead. And so even though it is obviously that the state has to prove whether or not he was in reasonable apprehension or fear of receiving injury because he's dead and nobody can ask him, it's really up to how they're viewing the evidence in this case as far as whether or not he was placed in reasonable apprehension or fear. And so that's why I think that this question is confusing based off of what we know about the law. And so I would prefer to just give them the correct law. There's nothing improper about giving them correct law and then including the facts of this case. It's answering the question without improperly assuming what they're asking is, I guess, the reason why I'm hesitant about giving a no.
All right, so not to quibble, but it says, isn't it true we should consider James Barron's likelihood of, quote, and they're tracking, reasonable apprehension or fear of immediately receiving a violent injury, close quote. That's the setup. And the question is, from the perspective of a reasonable person in the known context.
And that's why I don't think it's necessarily no, because again, nobody can ask Mr. Barron in that context if he was scared because he's dead. And so I don't know exactly what they mean by that, because typically if you have a live victim in an aggravated assault, you would elicit testimony about how did that make you feel? Were you scared? That's how you're able to prove this element. When you have a dead victim, you can't do that. And so you really are kind of judging the evidence based off of, if a person like Mr. Barron were in his shoes based off the evidence, was he in fear? That's why I think this question is confusing, because I don't know how they're thinking about it. And so to answer no, I think would be improper, because that implies that basically the state had to, we can't ask him if he was in fear. So they're going to have to kind of put their own imagination in the head of Mr. Barron in that context to say, was he in fear in that moment, which might be to them a reasonable person in that context.
All right, last word. Defense.
Yeah, the answer is to their question is no, because it is no. It's not from the perspective of a reasonable person in the known context. That's just false. And to not answer that is a mistake. So I think the answer is no. And one last thing, Judge. Ms. Bennett had said I didn't put the word or fear in my charge. And I just noted this error. In the statute, it actually doesn't say the word fear. It just says reasonable apprehension of receiving a violent injury. So the word or fear doesn't belong in the charge. I don't think we need to do anything about it now, but we don't want to remake that error by putting the word or fear, because it's not in the code.
I think that's pattern. This is straight from the pattern.
It is not in the code for assault.
Straight from the pattern jury charge.
Assault says commits an act which places another in reasonable apprehension of immediately receiving a violent injury. It's in 16.520A2. So or fear is not part of the code, so it shouldn't be in the recharge.
Okay.
I have it in my attorney folder. It's in the pattern. That's right. Take it. Here's the, that's the update. That's the most recent. Thank you. That's mine. Oh, this is next. That's mine. I don't know whose computer I have.
It doesn't matter, I don't care. One of them's fine.
Anything else from the state?
No, Your Honor. I just double checked that fear is in the pattern charge, so it wasn't an error.
All right, the final answer is on this is that I am going to put the no because it is responsive to their question. I hate to get into minor semantics, potentially no comma and then lead into, which is, I think maybe the better way to do it.
That's fine.
Okay. And then I'm going to go with Mr. Willis's 531 email language, but adding the two words "or fear" after the word apprehension.
Yes, Your Honor. Thank you.
So no comma, you should consider whether this, I apologize. You should consider whether the state has proved beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension or fear of immediately receiving a violent injury, period.
Yes, Your Honor.
That's C, hold on, that's C10, page 1 and 2, over defendant's over state's objection of the no. Sorry. Are you ready for question 2?
I think we are both in
Yes.
agreement, Judge, that the answer is yes.
Answer is yes. And will the court be sending, when you send back the answers, do you send back their sheet so that they can refer back to know what, you know what I'm saying? Because if they don't have their note because they've handed it to you, and they don't.
Yeah, so to answer your question, the packet you have is stapled with 3 pages.
Yes, sir.
I return that back.
Got it.
The original is with court order, so you're correct.
Okay.
Just in case they've forgotten the question, they're provided with what their question was. And then collectively, I'm going to finalize the paper that will go back as C12.
Got it. Thank you.
Thank you.
Okay. Okay.
giving the court reporter C11, which is question 2. Handing the court reporter what I believe is C12 is what we agreed, or what I stated, which is a copy of the response. Thank you. Handing the chief bailiff a signed copy of the response that y'all have, as well as photocopies of the 3 pages that they presented to the court. Defense, have you had a chance to review C12?
Yes, sir. And we have no objection to this proposed response. We will just restate our previous objection that ties back to the demurrer with respect to charging both species of assault for the record, and ask the court to rule again on that, just so we don't wait.
Noted and denied.
Thank you.
And then you object to the no comma, but other than that, we're moving on.
Yes, Your Honor.
Thank you. Anything else from the state?
No, Your Honor.
Anything from the defense?
No, sir. Well, let me ask this. As far as timing, would you prefer us to?
I'm just as anyone else who's in the courtroom, I can guess. I mean, I would guess that they're going to review that and either keep working for longer or
Yeah. Okay.
potentially reach a verdict, or potentially say, can we come back another day? So they're either going to let us know, I would think, within about 15 minutes or so, or they're going to do a deep dive.
Can we have a picture real quick?
Yes.